Beautiful people, welcome back. It's important to know that to change any given effect, one must change the cause. The note of mortgages and real properties. Contention that a lot of people make when the issue comes down, when a lis pendens or closure is done against them, is that whoever is filing that lis pendens is creating an effect of something as a distraction from the true cause. What most do is they go into the circumstance, arguing the effect. The effect that the other party filing that foreclosure against you is doing is they're not foreclosing on the real property. What they are foreclosing against is the contract that you signed with some spurious man or woman under some supposition that you are liable one way or another. Besides the principles and rights of obligation of contract that's in state and federal level, which is being enforced by them, there's another thing that's causing them to be able to come in, make demand, and then hold you liable against their demand, whether it's valid or not, whether you realize it or not. One of those is the principles of acquiescence, which you already know, and there are many maxims about that. If you keep silent about it, it's as though it's all right. As always, a bully will always keep doing something if they are convinced that the one being bullied cannot dictate otherwise their reality. In order for an effect to be changed, the cause is what you have to deal with. Most people, when it comes to pen and paper game, especially if they are in a tight situation, a hot spot, whereby it's not preliminary, it's not preparation, it's the heat of the moment, it's urgent. It's one of those situations where they lose something very valuable to them. In this case, shelter, which is one of the primary requirements of any sentient being, whether it's an animal or not. Shelter is important. When people get into said circumstance, what they do is they attempt to change the effect of lack of security of shelter by working with effect. At that point, they fail to see that that's merely changing one form of distress for another. They're exchanging one form of distress for another. You're using effect to deal with effect. You're using the same side of a magnet to try to pick up a magnet. You're supposed to flip that magnet that you have so that the polar opposite can latch onto the polar opposite of that magnet that you're trying to pick up. You're supposed to use a cause to change an effect, because the effect is the aftermath. In order for the aftermath to be altered, you have to go to the core of it. The effect is the contract dispute that's been foreclosed against. Again, the land is not what is being foreclosed against, if we've yet to figure that out at this point. It is the contract based on rights and obligation of contract that is being foreclosed against when people deal with foreclosure. That term foreclosure, they're not foreclosing against that property. They're not foreclosing against that property, aka usually the banks. There are always going to be exceptions, like landlord-tenant, whereby sometimes the landlord actually owns the land and the house. But we're speaking of, quote, the banks. Those banks are not foreclosing against the land or the house. The house, the air, the veins of any valuable natural resource, all that comes with the land. So the subject matter in the core is the land. They're not foreclosing on that land. Rather, they're foreclosing on the mortgage. The mortgage is the contract. The mortgage itself is the contract. In contract law, contracts can be foreclosed. What most people do is they fail to realize that banks, according to the National Banking Act and its twin sister called the National Currency Act, and according to the language of that contract called the mortgage, whatever type of allonge, there are many types of allonge that goes with mortgage based on the maturity date and what type of contract it is. Whatever type of allonge goes with a mortgage, whatever type of promissory note, meaning the monetary value. The mortgage itself is just the terms and condition. The promissory note is the amount to which the terms and condition is being created. And the allonge is any type of form of assignment or any type of form of securitization or other terms and condition that they don't want to disclose to the public. Like, you know how you would double close if you're ever into real estate, and the closing table, the one that you're buying or selling from, does not necessarily have to know that there are other parties involved. So you close with them, and then you finalize that, you pay the fees, and then on the other end, it's basically two separate doors. You double close. Well, banks do that all the time. And usually the one at that closing table with you, while you're happy that, okay, I'm getting this house, it's $300K, I'm moving to a better neighborhood, or whatever it is people have in their mind. The one at that closing table, either to a closing notary, real estate agent, they on their end might know about double closing, and they might in fact be double closing, but there are other parties whereby when you begin to read the language of that mortgage, you see that they can do more than double close. They can close up to about 15 separate times. This is before assigning that mortgage to someone else, which they let you know according to, rights and obligation, a contract that says, hey, we've sold the mortgage to someone else, the one that's going to be coming to you monthly to say, hey, pay up, or else it's going to be someone else. That's different. That's called assignment. We're talking about closing before they even get to the point of saying, okay, maybe we'll exercise the right of assignment. There's so much that goes on. Regardless of what goes on and all the different parties involved in the equation, that contract itself and everything attached to that contract is what is being foreclosed against. The reason the contract is what's being foreclosed against is because the bank or any other parties involved in the different forms of closure to finalize the interest. Because when it comes to contract, it's all about interest. Like an LLC, it will ask you how many percentage of the members owns. Well, the same thing exists when it comes to mortgage. There's a trust relationship with the mortgage electronic system, and there are sharecroppers with it. If you've ever done a Bloomberg audit on any given mortgage contract, you'll see it clearly. So now they're coming to you. They're saying, all right, you haven't satisfied the obligation of this contract, so we're going to foreclose against it. And part of the agreement is that if you don't satisfy your end of the bargain, you get to leave that land, because that land is the collateral. Now, after you've left, say they successfully foreclosed on the contract, not the land, the contract. Say they successfully foreclosed on it. Those who initially did the closure to finalize the contract in the first place and are sharecropping on the interest of it in the stock market they still keep getting compensated, even if a new contract is then attached on the land. More than one contract can simultaneously exist and attached to a land. It does not annul the previous ones. Even if they release it, the monetization still continue. The monetary interest still continues, unless the trust is dissolved. Of course, whenever trust is dissolved, liquidation occurs because the assets has to go somewhere, and in this case, the assets are the fungible instruments that are being traded and backed by someone's full faith. Since that's the case, and there are many hidden things involved, and the land itself, which is the shelter that the everyday man or woman thinks they are signing that paper about is not the core of what's being foreclosed. Should that not raise a red flag as to why someone can say they want to kick you out? Another thing you should think of is, in order for you to use something as a collateral, do you not have to first own it? A collateral is just saying for a substitute, meaning I will use this as a substitute for another thing in case it goes wrong. In this case, the contract that's been signed, if I can't give you this amount monthly, I'll give you this land. Do you not know that the presumption is that you already own that land in order for you to even use it as a collateral? Therein comes the principle of usufruct that we went over, which on a basic level there are two types. On an advanced level there's about 3 or 4. But on a basic level the two types of usufruct is you're able to use something that you do not own under the condition that you don't damage it. Or you're able to use something that you do not own. And that thing that you're using, if it's naturally expendable, you're going to replace it to its original condition. So now if you're using that land as a collateral, it's either you'll naturally own it or you don't. And you're simply invoking usufruct. What banks do is they put themselves in the role of God. And they say in order for you to invoke usufruct, in order for you to use this land, you're going to have to compensate us. Real estate is the biggest business in the world. It doesn't matter what anyone tells you confidently. If you ask them what is the biggest business in the world, real estate is. Humans are attached to real estate. One of the greatest things that's consumed is real estate, because from that real property you can create food, you can create shelter, you can create things that can multiply themselves and make you more monies. The banks figured this out. Because they figured this out, they go, all right, we're going to come in between you and your substantive right to have shelter. Part of those liberties spoken of within the All Declaration of Rights section on the state and federal level. But the thing is, in order for them to come in between that, when it comes to the ownership or the use of land, they have to have some type of interest in it. Predominantly. But they predominantly don't have some type of interest in it. So then they get you to sign a contract with them to validate their interest in your use of that land. No laws says that banks can own money. And if there's any verbiage that comes close to saying banks can own land, which there are verbiages like that within the national currency and outside of it, that comes close to saying banks can own real estate, there's still no evidence that they own these real estates based on the position and the language of the contract that they sign with people. And the rest of the Carta at 2011 affirms the same. Francis J. Bevilacqua III versus Pablo Rodriguez, May 2nd, 2011 to October 18, 2011. The effect is that most people defaulted on the contract, but the cause is that the contract could not have been valid in the first place. Because of this thing called title of ownership. This is old news that we're speaking of here. This is not something secretive that the banks themselves don't know, or that the everyday people do not know. There are many paths to take to fix the issue. But as you take those different paths, you have to know these things in the back of your mind, because these are the things that will shape the subtle reality as to whether what you're doing will work or not. These are the things that will shape your comprehension of the language of the proposal and negotiation when they come to you, when you back them in a corner. These foundational things is what would allow you to understand the importance of being able to see when they say, all right, let's meet in a middle ground. Subject matter in this case is dealing with jurisdiction, land court. A plaintiff did not have standing to maintain an action to try title, where although the plaintiff was in physical possession of the real property in question. A plaintiff did not have standing to maintain an action to try title, although the plaintiff was in physical possession of the real property in question. The plaintiff could not establish that he had record title as required by GLC 240 subsection 1. Given that record title could not be established by a single recorded quitclaim deed purporting to transfer title from the grantor bank to the plaintiff. In other words, the plaintiff is in possession of the land. And despite you being in possession of the land, which we've heard, not possession is 9/10 of the law, right? But that possession does not perfect your ownership and interest in title, because it's been merged up with other interests. In order for you to complete that 1 out of 10 that's left, to affirmatively say it's yours, you have to show proof of title ownership. Because the title of ownership was what gives you standing to maintain any right of action or to bring up dispute of title. What they do with mortgage, they put liens and cloud that title. They become the first lien holder, the second lien holder, the third lien holder. And do you know other types of mortgages attached to that land? Even after it's released, those mortgages are still active because they're fungible instruments with monetary value. Even after the mortgage is released, the monetary value of that contract attached to that land is still active. Just because you possess something physically does not mean you have the right of action to title of it or the perfected interest on it, even though according to the UCC, one of the ways to perfect an interest is to be in possession of it. But in this case, there's already a first lien holder. There's already a clouded title to that real property that this man or woman has physical possession of. So the title cannot be perfected. And this res judicata lets you know that you merely recording a quitclaim deed is not an evidence of title. The plaintiff could not establish that he had, quote, recorded title. Given that the record title, meaning the title that's on public record, could not be established by a single recorded quitclaim deed. A quitclaim deed just shows from whom any given property is going to. That's all a quitclaim deed does. Quitclaim deed does not demonstrate title in and of itself. It just shows that this Given property is going to this other man. But we really don't know who owns the title though, but we're just showing a trail of who's using it based on principles of usufruct. And the medium that we're enforcing usufruct through is the private contract called a mortgage, promissory note, and all the other allonges that we use to double, triple, quadruple close the contract on the forefront and the back end so that we can make as much money with it. The quitclaim deed is not an evidence of a title. In order for you to perfect an interest in something, you have to be in possession of it, and you have to have title to it, either as a first lien holder. And when they say you have to have title to it, what they're referring to is whoever the first lien holder is. For instance, as we went over on Patreon, when you really put that vehicle in any type of trust and you become the first lien holder, when they send that title out, they don't send it to the owner on the certificate of title. They send that certificate of title to the first lien holder. Now, if you're layering your trust properly, you already know that's to your advantage nonetheless, because it's going to be going to the express trust. That is how you want it. You want to be the first lien holder. But the thing is, there has to be a contract that validates that, quote, standing as a first lien holder, which gives one the right of action to maintain a title. So ask yourself, when it comes to land, are you the first lien holder to that interest of use of that land? Because that's all you can do with a land. It's meant to be used. And how the usufruct or the usury of it is measured is through interest. What they do is they place themselves as a front man to qualify the interest by making themselves the first lien holder through a private contract that's signed with you. It appears and seems convoluted at first, but once you really begin to get it, it becomes very simplified. But the main question at hand is, how did they get to a position where they can do such a thing in the first instance? And even if they somehow pulled it off and pulled the wool over people's eyes, is that contract still valid? Based on the language of the contract itself, because the contract makes the law, right? Let's not even look at anything else. Look at the contract and the language itself and the medium to which they enforce the contract. And you see that even they have no standing. So now it's one of those free-for-all situations. Whoever can prove at most that whatever they're disputing has the highest validity wins. It's the wild, wild west. There are many more intricacies, but that's the simplified summary of it. This you have to really get if you intend to discharge any presumed liability by way of that mortgage contract. Whether you're doing a court and satisfaction, whether you're doing GSA, whether you're doing the 1096 and 1099A, not 1040V voucher, all that stuff, not 1099 OID. And then the fact that discharging triggers a taxable event forces your hand to know how proper use of trust and proper laying of trust works anyway. And then when you really begin to comprehend what usufruct is and how principles and rights of obligation of contract is involved in this entire thing, you will see that they are functioning through trust. That's the only way they could double close, triple close, and more, through allonges. That is the only way that they could have came in the first place and say, all right, in order for you to use this land, you have to come through us. That is when and how you're going to be able to say, okay, wait, what makes you have the standing to be the one that anyone has to come through to use the land? And see, this precedes any contentions about whether proper consideration occurs. What ought to be brought up is the cause for that contract to even be initiated in the first instance, before the effect of consideration is brought up. Consideration is a very important part of contract, which is also important, but proceeded with something else first. Because also, when it comes to the principles of usufruct and the matter of equity as it pertains to use, so the thing is, whoever has put in more value into something, add that value that you've put into that thing on top of the 9/10 of the possession, that will give you an open path to being able to claim title to that land, because you've taken care of that property for that long. That's the same foundational principle behind adverse possession. Adverse possession has absolutely the full 52-minute video is on the Patreon page. Take care and best of luck.